Good morning, everyone. We appreciate everyone's time to join us this morning to talk about a very important topic that affects our members and our contractors throughout the country, and that is, what does it take to pre-qualify for industrial projects as well as other projects? We're really pleased today to have General President Eric Dean with us to welcome everybody, and so I'd like to turn it over to General President Dean.
Hey, how are you? Good morning, everybody. I just wanted to thank you for taking the time to participate in this video forum. I'd like to thank the Safety Department. Through Impact, we've expanded the Safety Department, and we've now, we started with a one-man band. We've added administrative staff, Canadian content, and most recently, Wayne Cressip to give us his subject matter expertise on safety and on industrial project-based safety. So each and every one of you have a part. You know, we rely on our members. We do the training to keep them safe on the job. We rely on the employers to provide the safety equipment and the time and means and methods to deliver the job safely. And last but not least, we rely on the owners to promote a culture so that they expect the workforce on the job and the contractors to adhere to strict safety regimen. That way everyone goes home safe every day, intact like the way they went to work. So taking the time today, I know that they got a really robust agenda. I don't want to speak too long. I just wanted to tell you that I appreciate everything you do on behalf of our members, keeping them safe through this crazy COVID period, but more importantly, just in the normal, regular routine construction. I believe if we see something, we say something, and if everyone takes safety seriously, we can drive to zero fatalities, zero incidents, and keep our members safe, your employees safe, and for the good of our nation, get our projects up and running and ready to go. So with that, thank you to Steve and the entire team for what you're going to do. And I'll get out of the way and listen to the people that are a lot smarter than me about safety subjects.
Thank you, General President Dean. And just to reiterate what he said is puts things in perspective when we talk about people either losing their lives or getting hurt on a job site, disabling injuries. So this is what it's all about. This is the business we're in, is to protect our members, give them a livelihood, a nice career, to be experts in the ironworking industry. And so this is what it's all about. Before we get started with Wayne, on our screen, you'll see a new contact information for the Safety Department. When COVID-19 started, we needed to expedite the process in getting contacted because we were flooded with calls regarding numerous items. So we have a dedicated phone number that you see there on the screen that you can contact us anytime. When you contact this number, you can get a hold of Wayne Cressip, Jeff Norris, Christy Rose, myself, or leave a general number. In addition to that, we have a dedicated email address where if you want to send us something or if you have a question, it's a good poster board where we can pick up messages from our members and contractors throughout North America. So please jot down this information and contact us if you have any questions where we can help you. I'm pleased to introduce Wayne Cressip. As General President Dean mentioned, Wayne came on board, I believe today is his 1-year anniversary. Wayne, correct me if I'm wrong, but I believe it was the 29th of July last year, which was the very first start date. So we're really pleased that we have the resources to have Wayne on board in the last year, and it's gone by very fast. We've addressed many issues. Okay, we hit the ground running, and so Wayne has been very helpful in the Safety Department. So would like to turn this over to Wayne. I want to also say that Wayne is one of the instructors for the Ironworker Safety Director training course. He taught this very subject, this topic on incident rates, who's managing them within your company, and how this is a very important function of your company operations. And so we've put this course on throughout the United States and Canada, maybe 7 or 9 times. We're really pleased that we have over 509 members and safety personnel that have completed this course, and many of which are working for project owners, general contractors, and our signatory contractors throughout North America. So Wayne played a very instrumental role in addressing this topic as one of the 10 topics that got raving reviews. So please welcome Wayne Cressup.
Hey, thank you, Steve and Eric, and welcome everyone. Glad that you joined us today to talk a little bit about a little bit of OSHA record keeping and contractor pre-qualification. Really appreciate the opportunity to share with you some information. As you may be familiar, now that we've been doing a lot of these Ring Central meetings through the pandemic, you probably have seen the functions here. So if you have a question, Jeff Norris, our Canadian Safety Coordinator, is going to be handling the Q&A today for us. So if you would, please just use the Q&A button on the app and ask your questions there. We have disabled the chat function for the purposes of this, just to allow us to be able to better handle the program today. And so if you do have other questions that do come up, we'll do the best we can to try to answer them. If you get into a lot of specifics regarding record keeping or workers' compensation or other issues, we may not be able to handle those questions today, but we could try to deal with those on a case-by-case basis as they come up, because some of these things can be very challenging to discuss in this type of context. So one of the other things that we're going to be doing today is also pull questions. If you've been a part of the Safety Department's webinars over the last several months, we've included some poll questions. And if you would, there's going to be a question that should pop up on your screen. If you take a second to kindly let us know who you represent here. If you're an owner, client, contractor, union member, or somebody outside of those organizations, we'd like to know who you are today that's joining us. All right. Terrific. Thank you for responding and letting us know a little bit about who our members, our attendees are today. You see we have a larger majority of contractor representatives, followed by union representatives, our owner clients, and then some members, and we have a few others. So some of the objectives of what we want to discuss today is to go over some basic OSHA record keeping and reporting requirements, talk about some of the top 10 record keeping questions that we have a tendency to be asked. We'll discuss a little bit about the importance of managing incidents. And as Steve pointed out, based on a lot of these things when it comes to contractor pre-qualification, is who's handling those incident rates within your company and understanding the impact of those incident rates, such as a total recordable incident rate and a days away restricted or transferred rate. And then we'll also want to try to use that information to give a little bit of understanding of how those rates impact an employer's ability to bid future work. And then finally, we'll also get into some of the benefits of pre-qualification, talk about some of the metrics that are used in pre-qualification, and we'll go through an example, some steps to it, and share some additional resources where you can find more information. So the first thing I want to do is share a little bit about perspective. When we start talking about record keeping and pre-qualification, it seems to be a really big thing that kind of gets potentially blown out of proportion when maybe it might not necessarily be as bad. However, on the same premise though, if we happen to try to focus a little bit and pay a little bit attention to what we're working on when it comes to pre-qualification, all that hard work should pay off in the end at some point. So that's my little brother here, and I had to share a little bit of that, again, based on that perspective, right? Just like those fishing photos, the closer you get to the camera, maybe that perspective changes a little bit. So to talk a little bit about some of the OSHA record keeping rules, the standard itself is actually written in a question and answer format. And one of the things I wanted to point out is that it's oftentimes done as the standard itself is also handled through a lot of letters of interpretation. And so I would suggest to our members and our contractors who are on the call today to look at those letters of interpretation on the OSHA website. And I would suggest that you keep a file of those letters. So once you see them or you have them, take them, download them, or print them out and keep them in a file, because sometimes they have a tendency to either disappear or get relocated on the OSHA website, and it's a little hard to find them when you're looking for them when you need them at a moment's notice. So especially if you are making a decision as an employer as to why you decided to record or not to record an injury or an illness, that information will be helpful, and to have that right there with the employee file as to what you did and why you made that decision or that determination. So for those that aren't familiar, the record keeping rules, if those who know the construction standards, are found in 29 CFR Part 1926, but under the record keeping rules, that's Part 1904. And it's a whole different set of rules and regulations. And the problem with a lot of the record keeping side is that is for all employees, all businesses that have an employer-employee relationship, or have to maintain either some type of either doing reporting of injuries or doing the record keeping, the recording of injuries and illnesses. And when they make those rules, they make them for everyone. So, you know, construction's just kind of pulled into it. And sometimes we're, by being pulled into it, some of the rules may be a little bit challenging for the construction industry to follow. And as I mentioned before, these injuries and illnesses, the record keeping standard are open to letters of interpretation. And I put a link in here on this PowerPoint to where you can actually go to their interpretation page. And we'll make sure that we send a copy of the presentation out to everyone today where they can review this. So at some point, we'll send all the resources out post-webinar. So in order to look at deciding or determining whether or not we record an injury or an illness following the record keeping rules, there's basically a few sets of questions that we have to answer. And if we answer yes to each one of these, then we have to go through and we would record that injury or illness. So the first question is, did the employee experience an injury or illness? Very simple, yes or no. If they did, then we have to move on to the next question. Is the injury or illness work related? And if that answer is yes, then we'll move to the next question. Is your injury or illness a new case? And again, if that's in the affirmative, then we'll have to determine, does the injury or illness meet the general criteria or the application to specific cases? If the answer then to that question is yes, then we have to record that injury or illness. Now, the challenge that we run into in a lot of cases is that second question. Usually, you know, we find out in some way, whether it's through our reporting system with our companies, that an employee did experience an injury or illness. But the challenge that we run into a lot of times is that second and third question. Was the injury or illness work related? And is the injury or illness a new case, or was it a significant aggravation of a pre-existing condition? And those are certainly some challenges that we run into when looking at this and making those determinations in the record keeping standard. As far as the layout of the rule, it's broken down into various subparts, just like many of the other subparts in the construction book, you know, subparts 8 through CC, and just similarly, the intent here. Now, the purpose of the rule is to require employers to record and report work-related fatalities, injuries, and illnesses. Now, one thing I want to make sure I point out, recording or reporting an injury or illness or a fatality does not mean that the employer or the employee was at fault, or that an OSHA rule has been violated, or that the employee is eligible for workers' compensation or other benefits. All we're doing at this point is just determining whether or not that injury or illness has to be recorded on the OSHA logs. And so that's the only intent here with the part of the standard. And as if you've participated in the training that Steve talked about with the Iron Worker Safety Director training course, and make sure that we clarify that the OSHA injury and illness record keeping and workers' compensation are separate issues and they're independent of each other. And it's oftentimes confusing because we'll use terms interchangeably when we refer to a certain type of injury, that's permanent, partial, or temporary total, or restricted duty. And all of those different terms tend to be workers' comp type terms, or potentially cross-referencing into an OSHA term like restricted or transferred. And that makes it a little confusing when we're trying to determine those record keeping criteria. So Some of you may be aware of the size of the company. If the company had 10 or fewer employees at all times during the previous calendar year, they don't have to keep the injury illness records. Now, they still may have to report a fatality or an amputation, loss of an eye, or an hospitalization of an employee. That would still have to be reported. But as far as keeping the OSHA records, unless they're directed by OSHA, the Bureau of Labor Statistics, to keep them, if there's 10 or fewer employees during the previous calendar year, they don't have to keep those records. And that is based on the number of employees throughout the entire year with that company. So if a company is hiring and laying people off throughout the course of the year, they have to keep that tally. And if that adds up over to 10 employees at the end of the year, then they would have to maintain those OSHA logs. So there are some other exemptions, but unfortunately for the construction industry, we are covered and we have to maintain those logs. And we have some different criteria. And we'll just spend a little bit of time talking about some of the recording criteria, and then the work relatedness, new cases, and the general criteria, and then the actual forms. We'll spend a little bit of time talking about that because the focus of today's webinar is on pre-qualification, and this is where those OSHA logs really come into play. So as far as the recording criteria, covered employers have to record each fatality, injury, or illness that's work-related, is a new case, or meets one or more of the criteria contained in the standard. And so, you know, when they do that, if they meet any of those recording criteria, then we actually get into the actual forms. And we're going to spend a little bit to talk about the OSHA logs here. So the form that you see in front of you right now is OSHA's Form 301. This is the initial injury and illness incident report. And employers can use this form or something like it as long as it asks for at least the same amount of information. And they can take this information, and if an injury or an illness occurs on the job, then typically a supervisor would fill out this form and then submit this to their company based on their company protocols. And once the company receives that information, they need to do something with it. Obviously, it'll probably prompt some sort of an investigation or some sort of a review to determine the work relatedness, the type of the injury, and the proper treatment to make sure that the member is taken care of. And then at some point, if it is determined that that is going to be recorded, then it has to be recorded on the OSHA 300 form. So just real quick, we'll share with you a little bit about the OSHA log. And this is the OSHA Form 300. And so a lot of employers are going to be required to maintain this OSHA log through the course of the year. And if an injury or illness occurs, this log has to be updated within 7 days of that injury or illness. And so typically what we'll see is you'll see an employer would make sure that they had to fill in the date up here, the year that they're doing the recording. In the upper right-hand corner, they would put the contractor's name here and the city and the state. And then to fill out the remaining part of the log, each one of these lines is a separate case. So we have under column A over here on the very far left, we have our case number, which can be used as a reference point. If we're trying to protect the identity of any of the employees, we may use a case number or other kind of a numbering system. Or again, in column B, we also have the employee's name. And again, if it's a privacy concern, we may use or substitute a different type of a letter or number type system to make sure that we protect the privacy of that individual. Column C, we would indicate the job title of that employee. And then column D is where we describe, or where we include the date of the injury. Now column E, we talk about where the injury had occurred. And then column F is a description of the injury, illness, the parts of the body affected, and the objects or the substance that directly injured or made the person ill. And that's a lot of information to contain in a very, very small portion here of the form. But that is a lot of information there, and a lot of times, you know, it may require a little bit of extra work to fill all that in, but just a very brief description of the injury or illness. Then the next set of boxes that we're going to talk about is classifying the case. Now, these go in the order of the most severe to the least severe. And so the most to the least. And the column G here talks about if we suffered or if the employee suffered a fatality, if it was a death. then we would indicate that by checking that box. If the employee had a days away from work, then we would check the next box, which is column H. If there was a job transfer or restriction, so maybe they didn't have any days away from work, but we had to put them in a different position on the job site, or had them on some sort of restricted or modified duty on the job, then we would check this box, because the employer had to make some sort of an accommodation. So that would be under column I. And then finally, under column J are other recordables. So if we didn't have anything else under G, H, or I, and the injury had occurred, but they returned to work and it was deemed to be recordable, we would mark that box under the column J as a recordable injury. Then if we happen to have under column H, any injuries that required days away from work, we would start counting the number of days under column K, and we would indicate that information here. And subsequently, if we had any jobs that were transferred or restriction, we would indicate that number of days over here under column L. And then finally, the last set of columns that are over here under section M indicates the injury, skin disorder, respiratory condition, hearing loss, or other illnesses that may have occurred to that employee in those boxes. And then finally, at the end of the year, we would take, if we had a number of employees that we had listed here, we would take all of this information and we would add up the number of cases all the way down here, and then we would indicate that number down at the bottom, and we would include all of those totals at the bottom of our OSHA form. So we would add up the number of cases as well as the number of days here. Now, if a company is fortunate enough to not have any injuries or illnesses that were recorded on the OSHA log, then they need to make sure that at the end of the year that they enter in all zeros at the bottom of the log to complete their OSHA log. So that's just a little bit of a review on the OSHA log itself and how it works. And then at the end of the year, we also have to take and fill in the OSHA 300A form. So all that information that we just tallied up and put at the bottom of the OSHA 300 log, we would now take and add that information and put it in the appropriate boxes for the OSHA 300A. So again, we would put our year in here, and we would come back over here and we would take all the number of fatalities and enter them from column G. We would put them in this portion of the 300A summary form. The total number of cases with days away from work from column H, we would put in this box. Column I, the total number of cases of job transfer or restriction, we would put into column I. And then column J, the total number of other recordable cases, we would indicate in that portion of the 300A form. And then we would add up the total number of days that were missed, and the total number as far as that were missed from work, or the total number of days with transfer or restriction. We would add those up, and then from the section in column M, we would put in the corresponding locations on the 300A form. So where I've seen companies run into problems is a lot of times they have a tendency to mix up the number of days away from work or the number of cases versus the number of days away, and they get those transposed, and I see really high numbers that may show up here. And that mistake can be very costly, because that will throw off a contractor's incident rate when we do our incident rate calculations. And that really causes them some problems. It'll throw them out of jobs before they even have a chance to get into them, just because those rates are going to be off the charts. We'll talk more about the rates here after a bit. As we complete our 300 form, we need to make sure that the employer fills out their establishment name, city, street, state, zip. And then they'll put their North American Industrial Classification Code, or their NAICS code. And for most of us in the steel and iron industry, it is a NAICS code of 23812 for structural steel and precast work. And a lot of times then the employer also has to indicate the average number of employees here on this part of the form, and then the total hours worked by all employees that previous year. They would indicate that information in this part of the form. And finally, this has to be signed by the highest ranking company official within the organization. And so that is signed by a company executive, their title, and then their phone number, and then it's dated down here. And that information is kept then. And this log, or excuse me, this summary form, the 300A, is what is then posted from February 1st to April 30th in a conspicuous location. Usually it's up on the job board or on the job trailer at the different projects from February 1st to April 30th, where employees can see it. And that's the summary log of what the employer did from the previous year. Now, one of the other things that I notice a lot of times, even to this day, I still see that highest ranking company official. I still see that individual as oftentimes being the safety director signs these. I'll still see where maybe the human resources or the payroll or accounting person signs off on those. And hey, if they are the highest ranking company official, hey, as a safety person, I'd love to see the highest ranking company official as a safety person, but that may not always be the case. And so if it's a red flag for me when I'm reviewing these and I see that the safety person or a payroll or accounting person has signed off on it, it's typically, if OSHA is going to be looking at these, that might be a red flag for them wondering where that highest ranking official is and where they've signed off on this. Now, I will say 20 years ago, when we were looking at the OSHA logs and what employers had, if we were to ask a contractor like a CEO or president of a company what their incident rate was, they would say, I don't know, you talk to my safety person. However, the way that the industry has changed in the last 20 years, if you ask the company's CEO or an executive what their company's incident rate is, they can pretty much tell you up to the minute what their incident rate is, because that's how dialed in they are and how important those rates are for those companies in being able to bid and procure future work. So we'll talk more about that as we get into the rates, but I think it's an important thing to mention. And that's why it's also important to see that CEO signing off on the 300A summary log. So as I mentioned before, the logs, as far as the forms, they have to be, the employers have to enter the recordable case on the form within 7 calendar days of receiving the information that the case was reported. And employers, so this was a federal form. Now, those that are in state plan OSHA states, they can also utilize those forms, either that or the one that they have for their specific state plan area. And they can also be kept on a computer as long as they can be produced when they're needed. So if it's requested by an OSHA compliance officer or an employee requests one to be able to see what the summary is or to see what their information is, they have that ability to be able to do it, and has to be able to be produced. So I mentioned before about the privacy protection, and there are some different cases where privacy may be one to maintain, such as injury and illness to an intimate body part of the reproductive system, injury, illness resulting from sexual assault, mental illness, HIV, hepatitis, or tuberculosis, or other needle stick and sharp injuries, or the employee just simply voluntarily requests to keep their name off for other illness cases. Those are certainly reasons where they may be concerned for privacy. As far as, and again, we see this in a lot of cases where a lot of companies will use some kind of a name or a numbering type of a system to cross-reference those to maintain privacy for their employees. And or if they submit their OSHA logs for like any kind of safety awards, a lot of times they will simply cross that information out or take that information off of those. They'll retract those off of the logs so that that information is not made publicly available. And again, so that's like the second point there. If you're giving it to those that are not authorized by the rule, they may remove those names. So as far as the other element that's been relatively new here in the last few years is the electronic submission of the records. So after we complete our OSHA 300A at the end of the year, establishments that are in the construction industry with 20 to 249 employees or 250 or more employees are required now to submit their injury and illness records from their OSHA 300A to OSHA. And that has to be done through the injury tracking application. So I put a link here in the PowerPoint where they can provide the agency their 300A information. And now that has to be done by March 2nd of the year after the calendar year that was covered by that form. So for example, in 2019, an employer finishes their calendar year, December 31st, 2019, and starting in 2020, they have until March 2nd of 2020 to submit that 300A information from 2019 to OSHA. Now, as of right now, OSHA views that 300A form data as confidential commercial information and will not release it to the public. However, I do want to exercise a bit of warning here that this is happening where there have been a number of watchdog groups that have been filing lawsuits against the agency to release this information and make this confidential information available. And so we're starting to see more of these court cases popping up and more challenges to this position that OSHA is taking, wanting to see that data being released. And so for the employers that are participating on this, pay attention to this because, again, the information, once it's released, and this has always been a concern for those in the industry, that if the information is released, there's no context with which it is being provided. It is simply the data. It is showing the number of injuries, the number of recordable injuries, or days away or restricted or transferred injuries, and the number of hours that that contractor worked in that previous year. So companies that submit this, they run that risk of that being made publicly available, and there's no context. Maybe an employee was hurt by an employee of another company, but because it was my employee, I had to keep and maintain that record because it was my employee who was injured. Well, that context is not going to be maintained when that data is released. So I just exercise that as a word of caution to be aware that there are more and more of these challenges are occurring, and to keep an eye on the court system to see if and when any of this information will be released. And obviously in the construction industry, the competitive nature of the industry and having this information could be utilized against contractors, again, in the bidding and pre-qualification process, especially if it's made publicly available. So one other part of the OSHA record keeping side that we need to discuss is the fatality and catastrophe reporting. The standard changed a few years ago that basically anytime that there is a fatality within a workplace, that has to be reported to the agency within 8 hours. If there's been a work-related amputation, loss of an eye, or an inpatient hospitalization of one or more employees, that has to be reported to the agency within 24 hours. Now, they don't have to report highway or public street or motor vehicle accidents outside of a work zone. They don't have to report commercial airplane, train, subway, or bus accidents. However, if it's during the course of employment and it is work-related, they may have to record that on their OSHA log. They just don't necessarily have to report that to OSHA. So I will say, we've had situations of this in the past, and just a word of caution again to our employers on the call today, is that a lot of times if there is an unfortunate incident where there is a fatality, we run into situations where it's chaos on the job site, there's a lot of things happening, and even though maybe the EMS shows up and maybe they already made a phone call to OSHA and OSHA is already there on site, this is one of those kind of nitpicky citations that can happen after the fact if the contractor did not pick up the phone and notify the agency that they did have a fatality on their job. So again, I actually, make sure that you do make that call if something happens, that you do let the agency know, even though OSHA may already be there. But if the employer did not make that phone call, that's an easy citation on the back end once the dust settles because they failed to make that proper notice to the agency. So,
Wayne, can you hear
yes.
me?
Yeah.
It's Jeff. I'm just going to ask
Jeff,
you.
great.
How you doing? I just wanted to remind our viewer audience that the Q&A is open. We haven't received any formal questions yet, but I was wondering if you could make a comment as I look at the attendees. We have some Canadians chiming into our webinar today, and I make a comment. I know you're speaking specifically to OSHA, but there is a connection to Canadian contractors here.
Absolutely. Thank you, Jeff. I appreciate you weighing in. So yes, so even though a lot of these forms are dedicated here for the states, there is a rollover and a carryover for our Canadian contractors that oftentimes if they're going to be bidding work, they're going to be required to submit their total recordable incident rate and their days away restricted and transferred rate just as if they were in the States. So that information will still need to be shared with the owner client or a general contractor or construction manager when they're seeking to bid that work. It's also as part of the pre-approval process if they are utilizing a pre-qualification system, such as any of the third-party systems, or even if they're being required to fill out a pre-qualification form, they're going to be asked to include their incident rates for, even though they're in Canada, they'll have to include those incident rates for their company to bid that work. Jeff, is there anything you wanted to add to that?
Yeah, that's a great summary. I did want to add that in Canada, because of the provincial and territorial legislation, just a reminder to contractors, for example, I noticed that there's some contractors from Ontario, and you're talking about reporting, that they need to be very robust in terms of tracking and keeping that documentation, but also reporting to the Occupational Health and Safety Authority, which in Ontario would be the Ministry of Labour, Training and Skills Development. Again, in Ontario, if you go out west, BC would be different than Alberta, different than Saskatchewan, etc. And to your point regarding pre-qualification, many of our industrial owners, for example, they will, during their pre-qualification questionnaire, request proof that the contractor has an accident or incident management system and a way of keeping track of all of the data that you're commenting on. So thank you for that.
Appreciate it. Thank you, Jeff. And so, you know, as Jeff was saying, you know, so a lot of these things, even though we may not think it actually does pertain to the Canadian side, it actually does cross over. And with the pre-qualification, as we talk about that later on in today's presentation, that information will be shared with the owner client, just as if they were in the States, especially if you're doing a lot of, like Jeff mentioned, that heavy industrial work. They do require a lot of that same information to be maintained. So one of the things that we get a lot of questions about are some of we like to try to do our top 10 record keeping questions. And so one of the first ones that we get a lot of times is, you know, what is the basic record keeping requirement? And so basically it's to make sure that employers are tracking and carrying their work-related injuries or illnesses. And that they are making sure that those are kept and maintained. Again, it's not to point any fault at anyone, but the idea with doing a lot of this is to determine where the injuries are occurring or illnesses are occurring so that we can take corrective measures to eliminate those hazards where those injuries are happening. And I think overall as an industry, we've done a really good job with that. And now we're getting into some areas where, you know, it's like as we're starting to see football training camps and things open back up again, we're starting to see that repetition and the practice going over and over again. And so I think a lot of it now is that repetition where we're starting to make sure that we follow through with keeping track of all those different types of injuries. So again, we're trying to prevent them from being repeated. Jeff,
Wayne,
another question, comment?
Yeah, there is a couple of questions, and I think it's timely. A question from one of our attendees is, are we mandated to report COVID-related illness on the OSHA 300? And what is the defining line of work related to my ironworkers on job sites?
Thank you. And yes, so the first part of the question, you know, is related to COVID-19. And right now, OSHA does have, and I actually have this included as one of the resources to be distributed after today's webinar, is the agency's interpretation or guidance on record keeping. And if it is determined that the illness, the COVID, was contracted at work, then it does have to be recorded on the OSHA 300 form. The challenge that we run into with this is that it's very difficult to assess, especially in the construction industry, where we have a transient workforce that is going from job to job, employer to employer. Sometimes they may even be traveling from state to state. And who all do they come into contact with as they make those transitions? And so unless someone is keeping a journal, a daily journal of all the people that they have, where they have places that where they have been, and the people that they have potentially come into contact with, where they can do contact tracing on the back end through their health departments, it's going to be very difficult to determine in the construction industry where that is where the work relatedness kicks in. But OSHA does have guidance on that, and we will share that information to everyone so that they can see what that guidance is. Because right now, yep, an employer, if it is determined to be work related, they do need to record that on the OSHA log. But like I said, because of that work relatedness, it is a challenge. And the second part of the question was on that work relatedness. That work relatedness is assumed based on the type of the injury, or based on the injury that just get to my notes here. It is presumed for injuries and illnesses resulting from events or exposures occurring in the work environment unless an exception specifically applies. The case is presumed work-related if and only if an event or exposure in the work environment is a discernible cause of the injury or illness or a significant aggravation to a pre-existing condition. And so the work-relatedness aspect of it, if it's a significant aggravation of a pre-existing condition, or if it occurs as a new event, then it is a part of being determined as being work-related.
And Wayne, could you also add to that comment whether or not these COVID-related work-related cases would negatively impact contractors' TRIR or their DART rates?
Yes, thanks, Jeff. And that is the slippery slope that we're on. If an employer records that illness, a COVID-19 related case, and they record it, the way that it is right now, that illness, once it ends up on the OSHA log, if it's not redlined later on in the year, that would then be those cases would count against that employer when they're calculating their total recordable incident rate. And it's unfortunate. That this is occurring, but that is the way that the record keeping standard is set and the way it's been determined. What's been a challenge is in some states, they have made determinations on the essential workforce. And if they were determined to be part of the essential workforce, then it was presumed that if they came down with COVID-19 as being in the essential workforce, that it was work-related and therefore would have to be recorded on the OSHA log. But again, because of the transient nature of the construction industry, it is very difficult to make that determination, even if it was an essential function or essential work, just simply because of the nature of the business, of people traveling from job to job. However, if there's cases where maybe it was a work camp, or maybe people were carpooling, and everybody in the car or that vehicle came down with coronavirus because they were on their way to the job site together, or they were in a work camp together and they came down with it, then all those cases then would be determined as being work-related and would need to be recorded. So, but absolutely, that would also negatively impact a contractor's incident rate when they do those calculations. What I would like to see maybe the agency consider, again, because of the construction industry is very unique. You know, we're the only industry really where, you know, those rates are used as a measuring stick to determine whether or not a contractor is quote unquote safe or not. And that may not always be the case based on those rates. And so what would be maybe nice to see the agency do, or is put out some guidance to say, look, we would like employers to record their cases that are related to COVID-19, but not use those as part of the calculation in determining their incident rate, just because of the unique nature of this. And what also complicates this is that right now, there are exemptions, like question number 5, there are exemptions from record keeping, such as the cold or common flu. However, COVID-19 is not exempted at this point from that record keeping standard. And that's what makes it really challenging. Other questions that we get asked a lot, Jeff, unless you have some other ones you want to weigh in on.
No, you're doing great.
All right, appreciate it. The other questions we get asked are, what's the difference between first aid and medical treatment? And in the standard, it lists about 17 different items that are earmarked specifically as first aid. And if any treatment that falls beyond those 17 items is not first aid, then that is deemed as being medical treatment and therefore has to be recorded as a recordable incident or a recordable injury or illness. And another example that we run into a lot of times is what is prescription medication. And the classic example of that is is somebody is injured, they are treated by a treating physician. That treating physician takes care of the employee and they prescribe them 600 milligrams of ibuprofen, which they're using a over-the-counter medication at a prescription strength. And therefore, because they issue it at a prescription strength, it would have to be recorded. And this is where it's important for occupational physicians and others to be involved in working with a treating physician so that they get the member the right care, the proper amount of care, but that they don't over-treat or over-prescribe to where that negatively impacts a contractor where they have to record that because a prescription was issued. Even if the prescription was issued and not filled, that still runs into a problem because of the paper trail that is generated as a result. So some other questions that we get asked a lot is the difference between record keeping and reporting. So as we mentioned before, the record keeping is actually noting the information on the logs and the summary form, and the reporting element is when there's that fatality that has to be reported to the agency within 8 hours, or if there's an inpatient hospitalization, the loss of an eye, or an amputation, that has to be reported to the agency within 24 hours. So there's two different elements there. And we've talked about some of the different exceptions of the record keeping standards, such as if there was an employee was participating in a voluntary wellness program, medical fitness, or recreational activity, eating, drinking, or preparing food or drink for personal consumption. So if somebody burns themselves or cuts themselves in the job trailer because they were making their lunch or making something to eat at break, that is not work related and not recordable. So there are some other exceptions to the standard. And we talked about with the COVID as another example of that not being accepted, but the common cold and flu being accepted from the standard, but coronavirus is not. So travel impacts the record keeping criteria based on travel status. An injury or illness that occurs while an employee is on travel status is work related if it occurred while the employee was engaged in work activities in the interest of the employer. And the only element that falls away from that is the home away from home criteria. If they happen to be in a hotel, that's their home away from home. So anything that happens there is not necessarily as work related. We talked about how the cases are recorded, and we also discussed a little bit about the record keeping forms already. So we'll talk a little bit about managing incidents and making sure that we have proper treatment and care for the injured and sick individual. That is of primary importance, especially with our signatory employers, making sure that if a person is legitimately injured or sick on the job, that they get the right care immediately. And the other key element is if that person is legitimately hurt, is making sure that they're taken care of so that we can get them back to work as soon as we can, which also helps improve morale on the job and also helps to reduce those incident rates. And as we talk about modification rates and other workers' comp factors, the sooner that we get employees back to work, the better that helps those rates on the back end. We'll talk more about that as we get into those rates. And again, those lower rates will help increase our ability to bid future work. So again, as General President Dean and as Steve Rank talked about earlier, all of this works together, whether it's our owner clients, our signatory employers, or our members. All have a role that is played in this and making sure that these are all handled correctly. So one of the other questions that was thrown out when we were first marketing this webinar was, who is handling the incident rates in your company? And I'm just going to try to rephrase this question just a little bit and use the old cliche of in the safety world of who's responsible for safety. And if you think about that, remember that old line of who's responsible for safety. Everyone's responsible for safety. Well, who's handling the incident rates? Well, in this context, in some way, everyone has some responsibility in handling the incident rate. That's everybody from the company leadership, the CEO, president of the company, CFO, chief operating officer, to the trades professionals, our men and women, brothers and sisters in the field who are actually doing the work. They have some role in this, as well as the safety director within the company who's providing support for the company and for the trades professionals, that safety director has a big responsibility in this as well. And ultimately, with those incident rates, that culture is developed, and hopefully we're helping to keep those rates at a lower number. Now, that safety director may also utilize a team of people to help handle their incident rates, because ultimately probably the safety director is going to be the person who's involved in actually filling out the logs and helping to do the calculations. And that safety director may depend on an occupational physician, where they may have some sort of a job description, and they may want to see what the essential functions of that job is for that specific iron worker, or for that specific task that an iron worker performs. They may utilize a workers' compensation specialist to help handle the various claims, to again help try to drive those rates down if they're constantly keeping an eye on any claims or outstanding claims that are out there. That helps to drive those rates. And they may even utilize a corporate attorney to look for other ways where they might be able to look for the latest and greatest information, where they may look to utilize the rules as far as they're making the choice on recording an injury or not. I've had the opportunity in my career to serve as a representative on some committees with some large employers, and weigh in on different thoughts when it comes to trying to make determinations on some cases as to whether or not they've been that they should be recorded or not. And it's very interesting to hear some of the different perspectives that come out of those conversations and making those determinations. And again, like I mentioned at the onset, whatever those decisions are, that you have documentation here, whether it's from your occupational physician, your workers' comp specialist, or your legal counsel, that you're utilizing as to the reason why you made those decisions, so that you have some supporting documentation to show why you made the choice that you made. So a little bit to talk about some of the incident rates and the understanding incident rates. So specifically, in the purpose of this presentation, we're going to talk about two rates. We're going to talk about the days away, restricted, or transferred rate. We're going to talk about the total recordable incident rate. And so if you take a look at if we go back to our OSHA 300 form, or the 300A summary form, when we add up all those different cases from those columns, this is where these numbers come from. So hopefully this will make some sense to you. I've color coded these on the screen here, that the DART rate is utilized here, is using the blue circles that are up here under column H and under column I. And the total recordable incident rate, if you look over here on the column, we're looking at the total number of cases that would come out of columns H, I, and J. And so when we have those all added up at the bottom of our 300 form, or on our summary form, when we see those, that's where that information comes from when we actually start to use that to calculate our incident rates. So taking that a step further, the way that we calculate that rate is we take the number of OSHA recordable incidents. So whether we're calculating a total recordable incident rate or a DART rate for those non-fatal incidents, we will take those number of cases, we'll multiply that by 200,000. Now that 200,000 is the equivalent of 100 full-time employees working 40 hours a week, 50 weeks a year. So that adds up to 200,000. That's a constant. That number does not change. And then the total number, and that's all divided then by the total number of hours worked by that employer. So to do an example here, off of our OSHA 300A form, we're going to calculate a total recordable incident rate. And to calculate this rate, we would add up the total number of cases from columns H, I, and J. And if we looked at that 300A summary log, we would see that we had 2 cases that were days away cases under column H. Column I had 3 restricted or transferred cases, and column J had 4 recordable cases. So if we add that 2 plus 3 plus 4, we have 9 total cases, times that constant of 200,000 hours. And then also off of that 300A form, we divide that by the total number that the total number of hours worked by that company in that year. which is the 453,836 hours worked. And if we run that calculation, we get a total recordable incident rate of 3.97. Okay, so keep that number in mind as we move through, 3.97. We'll talk about that a little bit more in a few minutes. Then calculating, as far as calculating a days away restricted or transferred rate, we'll take that same information from that OSHA 300A form, except we're not going to use column J in this calculation. We're only going to use columns H and I. Those are the days away or restricted or transferred cases. So in this particular example, we're only going to use 5 cases times that 200,000 hours divided by the 453,836 hours worked. And we end up with a DART rate of 2.2. So again, keep that DART rate in mind. We're going to talk more about that here in just a bit. So both of those numbers will play a role in that. And then we'll also talk more here in a little bit about experience modification rates, how that 3-year look back plays in, and how these numbers tend to be lagging indicators as part of an evaluation of a company's safety program. So we talked about the Bureau of Labor Statistics. I mentioned it briefly, and I talked about that 200,000 hours in the formula. So just if you wanted to hear that again, that's the equivalent of 100 employees working 40 hours a week, 50 weeks a year, and that's the standard baseline to help calculate those incident rates for all the different industries. That information is oftentimes submitted through BLS through an annual survey. So a lot of employers are asked every year to submit that information to the Bureau of Labor Statistics. And that information is usually 1 to 2 years behind. Typically, usually around October or November is when you see the preliminary data from the Bureau of Labor Statistics generated for the previous year or two when it comes out. So just to give you an idea of the time frame of when that happens. So when we look at the BLS data, this is one of the tables that comes from the Bureau of Labor Statistics. And this talks about the construction industry specifically. And what I'm going to do is I'm going to just blow this up a little bit so that you can hopefully see this a little bit better on your screens. And if you look in the construction industry, we talked about a NAICS code. That's the North American Industrial Classification System, that code. And we talked a little bit about when we were filling out our 300-day summary log about that number. And if we scroll down the page a little bit, we'll notice that structural steel and precast concrete comes in at a NAICS code of 23812. So if we look along that line and we want to take a look at what the total recordable incident rate is for the entire steel erection and precast concrete industry that's been submitted to the Bureau of Labor Statistics, we'll see that that total recordable incident rate is at a 5.2. You might recall from our example that we had a total recordable incident rate of a 3.97. So when we compare that, we want to know, well, how do we look compared to the national average? Here's where that information can be found, and here's how you can see how you measure up to the national average. So seeing that the national average for the same type of work is at a 5.2, and here as a contractor, I have a total recordable incident rate of a 3.97, that's pretty good. Now again, it's still not zero, which is where we're trying to get to, but it's still better than the national average. Similarly, if you take a look at cases with days away from work, transfer, or restriction, those total number of cases for that same NAICS code of 23812 has a total of 3.0 DART cases as an incident rate. And if you recall from our example, that incident rate that we used was a 2.20. So again, as we look at the national average, we're actually performing better than the national average based on that particular NAICS code. Now, here's where it gets a little tricky. When it comes to the pre-qualification process, we have a lot of companies that are out there that will take a look at a contractor's total recordable incident rate and their DART rate, and they'll compare that instead of to the numbers that are relative to the NAICS code, they'll actually compare those numbers to the construction industry as a whole. And if you take a look at the number that I just marked here, if we had a total recordable incident rate of a 3.97 that we had from our example, we'll notice that now we're actually above the industry average if we're being measured to the construction industry as a whole. And similarly, If we have a DART rate of 2.20, well, now we're actually above the industry average for a DART rate for the entire construction industry. And this is where I think it's important to make sure that when we're pre-qualifying, that the owner client or the pre-qualification organization understands that we want to make sure that we're being compared exactly within our NAICS category and not being compared to the industry as a whole. And as we talk about the formulas, when we look at these numbers are often influenced based on the number of hours that are worked and on the number of injuries that occur. So a large contractor that has millions of work hours a year, when they do that calculation based on the number of injuries, they could have a very small number just because they have enough hours worked to absorb the injuries. On the flip side of that, if you have a contractor that has a very small number of hours worked, yet they have a couple of injuries, that could shoot their incident rate way off the charts and throw them out of contention for work because they don't have the hours to absorb all the injuries that occurred. So a lot of times a small contractor, even though that constant is used of that 200,000 hours when we do those calculations, it oftentimes hurts those smaller employers based on those incident rates if they have injuries.
Wayne, on that note, if I can interrupt and ask a question from myself. Based on that comment, is there a movement to OSHA, and this again would apply in Canada where TRIR rates are used in pre-qualification, is there a movement to a different model? Because to me, it seems that this has a potential to, for lack of a better word, to penalize a small contractor that maybe is not working a large number of hours.
Yeah, that's a great point, Jeff. That is something that we oftentimes try to help educate our employers and our regulatory agencies. It's the unintended consequence of these rates. And the construction industry is really one of the only industries that these rates are utilized as a measuring stick to determine whether or not we're any good or not as far as our safety performance. These tend to be lagging indicators, meaning that the employee was already injured or became sick as a result of an workplace exposure. And those rates could be artificially high, and yet that's the number that we use. And we'll talk more about some of those examples after a bit, but what we are trying to do, I know there was a group within the ANSI A10 committee that was looking at leading indicators and putting a technical report together to discuss leading indicators as a better measuring stick, such as utilizing training, utilizing safety and health programs, utilizing workplace initiatives that help create a better awareness of safety and health on the job site versus the lagging metrics that have a tendency to be measured, such as the number of injuries that have occurred on the job to be utilized. So yes, we're working toward that, trying to help encourage the use of better leading metrics. The challenge that we run into with leading metrics is, again, determining what number is a good number. If we require everyone to have an OSHA 10-hour or 30-hour, what is considered compliant? Does it have to be 100%? Does it have to be 80%? Is that good enough? And that's always the challenge. We have workplace observations. We have, 80% compliance. Does that mean that, hey, that's pretty good? We're getting 80% of the people to follow through and make observations on safety and health on the job, and we're knocking it out of the park? Or does it need to be a higher percentage than that? And that's always seems to be a factor. And we also found that again, the size of the company, maybe smaller employers may have a little more of an intimate way of dealing with their safety and health systems than maybe a larger contractor. And so some of those leading metrics that some companies might utilize may not always work for a smaller employer. So there's definitely some work to be done on that.
Yeah, I think that would be an important movement in a positive way. And just a message out to the contractors that are online that recording your lessons learned, from incidents is important because it shows positive strides in change and how your safety management system is addressing incidents. And to your point about training records and showing to those construction clients that you're doing all the right things in terms of training personnel, our members. Thanks for that, Wayne.
Absolutely. Thank you, Jeff. So as we're looking at our slides here, these are some of the record keeping criteria in managing a return to work, is understanding obviously the cost of an accident and what that does to our contractors' bottom line. And when we do this course as part of the Iron Worker Safety Director training course, I actually take and go through and go through a chart and describe the cost of an accident, how much additional work a contractor has to come up with in order to absorb the cost of even something that could be considered a minuscule injury, such as maybe something like an eye injury that costs maybe $1,000 up front, but between the direct and indirect cost of that accident, as well as all the other hidden costs associated with it, actually requires that employer to come up with a significant amount of new work to be able to cover the cost of that incident. So we take time to talk about that in that safety director training course. We also talk about record keeping, OSHA record keeping versus workers' compensation, and how sometimes, even though something might be compensable, it may not necessarily be recordable, especially where that injury illness case isn't easily defined. We do run into some issues with gray areas on some of that. And then, proper and timely injury reporting. So, we want to make sure that the employee gets their proper medical attention, and we need to make sure that that notification process is handled in a timely and efficient manner. And then finally, the impact off the job accident plan. And I think this is something that's worth sharing with our members and our contractors, as well as our owner clients who are on the call today, is that, Impact has an off the job accident plan that helps iron worker members with a short-term disability that's caused by an off the job accident. And the idea with this is that it helps reduce workers' compensation rates for our signatory contractors, while still getting that member their proper care and treatment and some short-term benefits taken care of, so that it doesn't happen where our member potentially shows up on Monday morning after working on the ranch or playing softball or riding their motorcycle, and something happens, and then come Monday that all of a sudden they show up at the in the job trailer complaining of an injury that was sustained on potentially off the job. So this is a really unique program that we need to make sure that our members are aware of to take advantage of this. And I know if you look at the link that I shared here on the Impact website, there's some different video testimonials of how the program has worked for some of our members and how it has benefited them, and how it ultimately has benefited our contractors without having a significant increase in their workers' compensation rates. So in looking at our experience modification rate, I know this was a big question that a lot of people wanted to know about when we were talking about this program for today, is an EMR, oftentimes referred to as an XMOD, EMOD, MOD, experience rating. It's a term used in the American insurance businesses as a workers' comp tool, and it's the adjustment of the annual premium based on their previous loss experience. It's a very commonly used contractor qualification metric, and when you look at it, it's based on a numbering system of 1. Typically, 1 is average, and anything below 1 is considered better than average, as in a discount rated, and anything higher than 1 is considered worse than average or penalty rated. And that has an impact then on an employer's ability to bid work based on that rate. And it oftentimes has nothing to do with the safety performance in a company, as it includes all various types of losses: vehicle accidents, plane crashes, and somebody hit by a personally owned vehicle. There's a lot of other factors that play a role in using or calculating that experience modification rate. And if you look on the chart here that I have in the upper right corner of this slide, you'll notice that experience modification rate, it's a 3-year look back, but it's 3 years with a window year. So you're going back 4 and 5 years for calculating a rate to the current date. So in this example, like looking at 2018, to calculate an EMR for 2018, you're going back to 2014, 15, and 16, calculating that rate. And this is what's such a challenge for contractors, is that if they happen to have a bad year where they experience a lot of losses, that experience modification rate could go up high, And that's going to stick with them for several years in order for the time to go by for that rate to finally drop off their calculations. And so
Wayne, I
I
have
know
a
Steve
comment.
has some comments here. Yep, please, Steve.
Yeah. For 25 years, we've been dealing with owners and safety people using the experience modification rating as one of the determining factors in pre-qualification. And what we learned is the EMR is perhaps the worst determinant on a contractor's safety performance for many reasons. And it's a very subjective number. It's a number that includes reserve amounts. If you had 5 or 10 claims and you have excessive reserves that your claims adjuster puts on your claims, that's all included into your EMR calculation. And yet the employer, you find folks, have no control over how much reserving that the claims adjuster puts on each one of those 10 claims, okay? It's out of your hands. Secondly, cases of subrogation. You could have a 0 incident year, but yet you had 3 or 4 ironworkers that were seriously hurt because of the negligence of a third party. Maybe another trade person dropped something off the building or ran over you with a forklift. Those incident rates are reflected on your EMR rating. Why? Because it's what they call sole remedy. Workers' comp is sole remedy, and you have to pay for that claim. If Wayne gets hurt, if it takes 2 years before Wayne gets in a permanent and stationary position, that's how long you're going to keep paying on his claim to make your employee whole. After that, the insurance carriers will subrogate the claim back to that other trade employer that was responsible for that. But unfortunately, that claim and those claim costs will be included in your EMR calculation, and it's not fair. So the only thing I can advise here is if any of the employers, contractors on the line today, receive information about your EMR rating, and if it's over a 1, and yet you have claims that are reflected in that, you need to get your insurance broker involved. You need to get them to take this claim information and explain to the owner rep why your EMR rating is inflated, that you had nothing to do with it. You're just subject to numbers putting in that calculation. So it's a very, very bad determinant on safety performance. I don't think it's going to go away, but we have to be able to articulate to the best of our ability why that number does not pertain to you folks and your inflated numbers. So that's all I wanted to say, Wayne. Thank you.
Appreciate it. Thank you, Steve. And Steve, one other thing with that too is, how long does it take to get those claims resolved? And meanwhile, you're still trying to go after that work with a significantly increased experience modification rate. So that can be penalizing you even longer term.
Well, that's true. And in some cases, the employers are trying to get claims closed before all the information is sent to recalculate their EMR rating, right? However, sometimes claims adjusters for some insurance carriers don't do this in time, number one. And number two, they use this as a leverage tool to get the employer to renew with them. Maybe they don't want to close these claims. Maybe they know it's going to up your EMR rating. Maybe it's a way to keep their currency policyholder with them. These are a lot of cat and mouse games that have been going on for decades. So you have to be engaged in part of your business and understand what Wayne's telling you here today. And anything related to the EMR calculation, you have to be on point. Thanks, Wayne.
Great, thank you, Steve. And for those who are also members of the American Society of Safety Professionals, there was actually a really good article in the Professional Safety Journal. I don't know if you can see that here, but I'll also include that. That talks about using EMR for pre-qualification. This is the July 2020 edition of the Professional Safety Journal, the American Society of Safety Professionals. And it's got a really good article in there that discusses EMRs as pre-qualification, and exactly the things that Steve pointed out are why the EMR is not necessarily a good number to be utilized. Unfortunately, this is what happens to a lot of our owner clients when they bid this work. This is what they look for, is that EMR at or below 1. And as we were talking about in the previous example about being discount versus penalty rated, if you were at a 0.8 and you were discount rated, bidding against a company who was penalty rated at a 1.2, you're looking at a 400, in this example here on $1 million premium, you're looking at a difference of $400,000 for the discount rated versus the penalty rated insurance product. And you know, who's going to have the better likelihood of getting the job if there's that much extra money available when you're trying to chase that work? So
Wayne, I have one other analogy I'd like to share, if I could, please.
Yep.
We were talking yesterday, just as a way to kind of put this in perspective, is what if you, in your auto insurance, what if you got rear-ended at a stoplight 3 times in 1 year? Does that mean you're an unsafe driver?
Right.
And you had no fault, you were sitting there waiting for the light to turn green, and someone rear-ended you because they were texting? Does that mean that your driving record reflects that you've been in 3 incidents and there's question regarding your safe driving abilities? Absolutely not. So I just wanted to use that analogy. The same thing happens in the workplace when our members and your employees are hurt as a result of the negligence by another party, and why that it's not a determinant factor. So I just want to make that analogy, Wayne. Thank you.
Steve, great point. And you know, like what Steve was talking about here on the pre-qualification side, with those rates, you know, that most owners, they want a rate that's at 1 or below 1, and sometimes they'll even lower that threshold to like a 0.99 or a 0.9. And the reason they do that is because if a company experiences a significant loss, that, like Steve said, that rate is going to be with them for a number of years. And that's going to impact their ability over a number of years, a period of years, to be able to go after work. So a lot of times what they can do is they'll go out of business, go back into business as somebody else, or doing business as, and then they start over with a brand new experience modification rate of 1 again, that allows them to get back into the good graces of an owner or client to be able to bid that work. So in a lot of cases, it's a little bit more difficult in some environments than it is in others, but that is a tactic that is often used, is by playing that game. And so a lot of times if an owner or client or a general contractor isn't aware, that's, you know, they're just going to see those numbers and base their decision based off of that rating.
Wayne, we do have a question that's related to this topic, and we know that documentation and more documentation is key. Is there any set monetary rate or hidden penalties that we should be concerned about during this time of industry modification and slow growth?
Boy, that's as far as any hidden things. Well, the challenge that we run into right now with this time is with dealing with COVID, is that again, determining, you know, we've had a lot of states have made different interpretations on those that may come down or test positive for coronavirus, and they may, and some politicians may be encouraging workers to file for workers' compensation, which then would potentially impact an employer's experience modification rate down the road for the illness. And there could be some long-term impacts with that. So definitely something to be paying very close attention to. And again, I think this is something that some of the states, when they were looking at this and they were looking through the National Commission for Compensation Insurance, that they were trying to put some caveats in there to say, look, you know, we want to make sure if somebody does come down with coronavirus, that we get them taken care of, we get them back to work, we get them healthy and take care of them. But at the same time, that those cases are not utilized in our experience calculations. And so I know some states had put some of that in some of their language, and some other states have not. So it's all going to depend, and it varies by the different states. So in this next slide, I just have an example here, another example of an experience modifier based on premium. of a modification rate of average of 1.0 versus a mod value of 0.70, and seeing what that dollar amount actually is. So that's the lowest premium that they could achieve if they had 0 losses in that rating period. So just again, another example to show that's almost a $54,000 savings right there, just in managing their costs and being able to help modify or influence their modification rate. So as Stephen was talking about earlier, here are a number of different metrics that are utilized or factored into an experienced modification rate. All states differ in how their EMR is calculated. Indiana, Ohio, Michigan, Illinois, for example, all calculate their EMRs differently. The state of Ohio is what is known as a monopolistic state when it comes to workers' compensation insurance. There's a few monopolistic states left, but others are also open market. And so it makes it very challenging trying to, based on those calculations. The other problem is like the second point, it's derived off of payroll hours. So if you happen to have a lot of work in one state and not a lot of work in another state, those losses, even if you had 0 losses, your EMR could change based on the amount of payroll hours and the work that's being performed in each different location. I mentioned the rates for the codes, they differ in every state. And so, again, that causes an influence in the experienced modification rate. The workers' comp laws, as I mentioned before, are different. Self-paying claims will also help lower an employer's experienced modification rate. So a lot of times if there's a claim or an incident, the employer can elect through their workers' compensation program to self-pay up to a certain dollar amount of a claim. So in some states, they may say, well, we're going to self-pay the first $15,000 of an injury or an illness claim, and we'll take care of that. And that actually will help them lower their experienced modification rate if they pay that initial amount, or they self-pay. There is a minimum EMR that you can achieve. It's not 0, so you can get as low as you possibly can, and once you get to that baseline, that is it, and you will still be forced to pay something. In some states, they have what's called a group rating program that do allow for similar contractors to all band together and participate in a group rating, and they all benefit from a discount then as in that group rating. Now that's a good thing, that everybody gets to benefit when all the things are good. However, if it can be a negative thing. If you're an employer that suffers a few incidents, you could get kicked out of the group and then go from having a really good experience modification rate to an abnormally high modification rate just because they threw you out of group and now you're on your own. And that could have a negative impact again on a company's business and their ability to bid future work. As we talked about before, it changes every year. The workers' comp claim again could be compensable, but maybe not necessarily OSHA recordable. And you're at the mercy, as Steve pointed out, you're at the mercy of an assurance claim representative who you've probably never met before. And they're in the back there behind the curtain pulling the strings as to determine what that rating actually is. So certainly some challenges with this. And as Steve pointed out as the last point in this slide, that it's arguably one of the worst metrics you could use to measure a contractor's safety performance. So we put a lot of these different things together as far as the lagging indicators. And to help get through this, the next area that we want to talk about is pre-qualification. So there's a poll question here. I'd like to ask everyone to take a moment and share with us what your biggest barrier to pre-qualification actually is. Are you dealing with any of these issues? Hey, does it take too much time and resources to become pre-qualified? Does it cost too much to apply and use those third-party programs? Hey, our company rate just isn't good enough, so we don't take the time to pre-qualify. We don't have the programs, or is it another reason? So thank you for those who participated. And it looks like the time and resources and the cost are barriers. So we'll talk about some of those challenges that companies have. So looking back years ago, when it came to pre-qualification, there were a lot of different forms that companies would utilize, whether it was a general contractor or an owner-client that would utilize to try to get all of the people bidding work for that project to get them all bidding or singing at least from the same hymnal or singing from the same song. So at least they had something that allowed for a fair assessment of a contractor's safety program and their safety performance. And so a lot of times it was done in a form that was either a checklist or a larger document that would be shared with the company, and then they would take that information and fill it out. And it would contain general company information, safety information, their last 3 years of total recordable incident rate and DART rate data, any fatality information that they might have, OSHA citation histories for the last 3 to 5 years, safety programs and meetings that they are conducting, any safety inspections that they do, what they do in safety training and orientation, what they handle, how they handle their drug-free workplace, and any injury and incident investigation programs or techniques that they utilize. So all of those things were contained as part of that pre-qualification system. And then lo and behold, we got a little bit smarter, and years later now we've come into different type of pre-qualification. So instead of using forms, we are now utilizing third-party software providers. And so, you know, if you think about this as a consumer, if I don't know anything about a product or a service that somebody is providing me, what am I going to do? I might take a look at, now personally for me, I'm a huge advocate of consumer reports, whether it's buying a TV set or a pair of boots or a pair of tires for my vehicle. I like to go to consumers and see what the ratings are from an independent third party that's going to tell me that the tires that I'm going to buy for my vehicle are going to last me a long time and they're going to give me the best bang for the buck. And if we think about that as a consumer, you know, that's what we would want, right? We're going to, you know, go and look, if I'm looking at having work done at my home, would I go to the Better Business Bureau or to maybe Angie's List and see what kind of ratings are out there for that company that might be doing work at my house? Or maybe if I'm buying a used vehicle, will I look at that Carfax? So that all plays a role in what I might do personally. So if you think about it from an owner or client perspective, that, you know, whether that's an automaker or somebody working in the petroleum industry, or the chemical industry or the power industry, you know, they are looking at the same thing. They may have very little knowledge or information about a contractor that's going to come into their house to do work. And therefore, instead of going through the paper route of having them submit all of this information, they utilize the services of a third-party company to help separate that out for them on their behalf. And so in a lot of cases in our industry, we have companies that are out there that, like Avetta, which has now absorbed PICS auditing and Browse. So those that may utilize those services are now under the Avetta umbrella. We also have IS Networld, PEC Safety, for those that might do oil and gas type work or refinery work. And then Veriforce and Construct Secure are other examples of third-party pre-qualification companies that provide this service. And a lot of this is all done online, and it is a long process. So what I would like to do is, I've got a poll question here that we're going to ask first, and we're going to ask, are you actively using third-party contractor pre-qualification services? And if you would, just kind of weigh in and let us know yes or no if you're using. We'd like to know that. And we'll give it another couple of seconds. All right. So yeah, it looks like 59% of those that are on here are still utilizing them. And I'm going to do a follow-up here. Which third-party pre-qualification services do you use? So if you would, please indicate Avetta, ISNet, PEC Safety. And if you use more than one, please indicate that as well. There's an option in here for you to check off a whole bunch of boxes. So please let us know which one that you're using, or which ones you're using. Okay, so what we're seeing right now is a lot with ISNet and Avetta taking the primary numbers. So thank you for sharing that information with us on the poll. And so to take the next step here, I'll just use an example here of what it's like to go through ISNet as an example, and how you would get set up to use your third-party system. So there's a few different steps of what you would utilize. And the first off is, you may have situations where a company, an owner-client, may actually even come to your business development person and say, hey, you know, Joe, we got a job coming up here, and we want you to bid the work because we think it's right up your alley. We think you'll do a great job. We'll do it with a good price and nobody will get hurt. but hey, you know what? You got to do it through, you got to pre-qualify through ISNet. And so now the business development person might be with that company, might be running down the hallway to the safety director saying, hey, we need to get set up in this. And my point with this is that don't expect that this is going to happen overnight. This is a process that could take a company dedicated to this just for one client potentially to get set up from scratch. It could take them several days to, depending on how sophisticated their program is, to many weeks or months. So if you run into that situation where you have a job that's coming up and you have to get into a pre-qualification software program, you better give yourself enough time to be able to do it. So first off, you have to get set up and get connected to your client. So if you're contracted by that company or contacted by that owner client to bid the work, this is where you would get logged in and you would get set up, and then you would get connected to that client for that specific job location. And then you're going to have questionnaires that you're going to have to fill out. And in some cases, if they ask for all, now this is stuff that the owner client requires, that they set this up. They don't make ISNet or Avetta, they don't choose these. These are all menus or options that are selected by that third party, or excuse me, by that owner client for that third party to require to be filled out. So in this example, there's questionnaires here of general information about the company, leadership and commitment of the company, and every one of these are questions that are going to be asked. And there can be over 2,000 questions asked about that company that are going to have to be filled out in order to move through the questionnaire. So again, you have to give them enough time to be able to address all of these questions and have the programs in place. Now, one helpful hint. Now, one of the things that we run into, the next step is like the safety programs. So in this example here on the left, you'll see that they have been required to have safety programs for aerial lifts, asbestos awareness, assembly, disassembly of cranes, and so on, all the way down through the list, and that they have had to be verified through their system. Now, depending on the program, a lot of times these programs are word checkers. So a helpful hint would be to take a look at the way the question is worded, and if that question includes certain keywords that don't exist in your specific safety program, say for that aerial lift program, then you might want to add those words to your program before submitting it, because it's going to check and look for that, and it'll check the boxes then with their software to make sure that, yep, it's okay and it meets the compliance of being verified through our system. So you're going to complete these programs. And then the next step is verification. There may be training verification or specific training that has to be done. In this particular example, the contractor here had to have permit required confined space rescue training for their supervisors. And so it shows and documents here that they had completed the training, that they had passed it, and that everything is up to scratch for that specific type of training that's required for that particular owner client. And then finally, there's other documentation that has to be submitted. And in this section here is the insurance information. As Steve pointed out, you've got your commercial general liability insurance, any automobile insurance, any other policies that need to be shared and uploaded through the system would be done at this point in the process. And then any safety statistics then on the back end that would be entered. So your number of employees, the hours worked by the company, the fatalities, the days away from work cases, restricted or transferred cases, some of other recordables, and all of that, all those cases that go back then for each year that you're going to be asked to submit that data. And so there's a fair amount of information that needs to be shared with the safety statistics that would go into that application. And then finally, once you get all that done, you're waiting for the review period for the owner client then to look on their end of what was submitted through that third-party software program and make a determination as to whether or not that your company was in compliance. And so typically a lot of the evaluation criteria are the thresholds here would be a total recordable incident rate, in a lot of cases less than or equal to a 3.0. I know some companies that actually have a TRIR of 2.0 in order to bid work at their locations, depending on, again, on the company and the industry. A total recordable incident rate at or below the industry average for the industry. So again, if you're being compared NAICS code to NAICS code, that you're at or below the industry average, a fatality rate of 0, an experience modification rate of less than 1, which we've already discussed, and then a safety and health manual that's at least 90% in conformance, and that your insurance certificates meet all the requirements of those thresholds that were required by the owner client. So now there may be situations where you may not qualify for one item in here. Maybe your incident rate is a little bit off, and you may need to submit a request for a variance from the owner client. And there are functions in those software programs that would allow you to submit for a variance, and hopefully the owner client would take those issues that you might be sharing under consideration. Maybe you had a high EMR and yet there was a change in leadership at the company, and things are going down a different track, and there's been some improvements with the programs. And maybe those are things that you might share that might help convince an owner or client that you're making good choice, making good progress toward driving that EMR down, and that you would like to be considered. So those are some of the different situations and cases. Oh.
Wayne, can I just interrupt on that note? Part of setting up these accounts with ISNetworld, Avetta, PT, is providing your OSHA 300 logs for the past, I believe it's 3 years, if you're a US-based company. The question from one of our viewers earlier was, are these companies subject to privacy requirements regarding those 300 logs?
So yeah, in a lot of cases, what they may do is they may redact some of the information that's on their 300 forms, like take out the employees' names, or use another type of a system where those names do not show up, or they may only require them to submit their 300A summary log, and that way they only see just the summary, so no information, no names are shared. So that's a way to help protect the privacy of the member of the employee that might be on those logs. It's also a challenge, because we have sometimes companies, run into the risk. Now, the other problem that we run into with this third-party stuff, and this is a lot of the comments that I get from our contractor community, is that, Wayne, this is great. We put all this information in, we submit everything to these third-party vendors, and then we get a grade. It's now either the grade, once you get your review, it's either you get a grade of pass, fail, a red, yellow, or green, or you A, B, C, D, or F, okay, grading, depending on the company the third-party company that's being utilized. And so that information, then depending on your grade, you may have to go through and make some changes to increase your grade to be accepted or pre-qualified to do that work for that client. The challenge that they have is that this is all well and good, but the programs and everything that I submitted, once that's all done, nobody really checks it once I get the job and I get into the gate. And so, that's a frustration for a lot of our contractors, is that the same program that they utilize to get in may not necessarily be the same program that's being followed once the job actually starts. So that's certainly a challenge. Other issues that come up is the cost, and which is our next poll question, is one of the other concerns that we run into. And so, if you would, for those who are still on here with us, what do you spend? If you're a company and you're spending money on pre-qualification, can you share with us how much you're spending each year in annual subscriptions to these third-party vendors? We appreciate any and all feedback with this, because this helps give a little bit of insight of where our contractors are struggling. Thank you for participating. It looks like most of our contractors are in that $5,000 to $10,000 a year range. And so I think that's one of the challenges that a lot of our companies find extremely frustrating, is that they're spending a lot of money bidding or pre-qualifying through these software programs, and they're not even guaranteed that they're getting the work. And so it's an outlay of cost every single year that are built into their businesses, and that certainly poses a challenge. And then obviously then the fee structures that occur with these third-party programs also create challenges, because these prices are not going down. And the more that contractors are being forced to utilize these programs and these services, the more that those costs run the risk of increasing. So certainly more challenges for us in our industry. With that, I do have I'm pretty much wrapping up most of my comments here this afternoon, and this morning for some in some parts of the country and Canada, Western Canada. I would like to thank Matt Kuhn and Jim and Randy Seaver at PSC Crane and Rigging for their assistance in helping me with some of the contractor pre-qualification information. Matt, really appreciate the help. And I also want to thank Ryan Pollock with Matrix North American for some of the information that he was able to share regarding experience modification rates as we put this together for everyone today. So again, thank you for your help. Finally, a couple of other housekeeping points, and then we'll open it up for any other questions that people may have, is the Ironworkers and Impact have a safety and health roundtable scheduled virtually for September the 1st, 2020. And if you have an interest in participating in the roundtable, please reach out to us at the safety@IWI email or the phone number, the 800 number that Steve shared, and we'll put that back up here on our last PowerPoint slide. If you'd like for more information to participate in that. And something else that we've been working on in the Safety and Health Department is the Lunch and Learn program. We've been working on this with a number of our district councils. It's a Lunch and Learn safety hour. And because of all the issues that have come up with coronavirus and the restrictions on travel, we've tried to work with our district council presidents and coming up with a Lunch and Learn safety hour. We originally were working this past year on coming up with safety summits within each of the district councils, but because of these challenging times, we're going to try to do them virtually, but we're only going to limit it to 1 hour. And as you can see, when you get a safety person talking, it's hard to limit them to speak in just 1 hour. But we'd encourage you, if you have an interest in participating, our first one is going to be held on August the 19th with the St. Louis and Vicinity District Council. And then I believe we have another one scheduled for August 20th with the Southern Ohio and Vicinity District Council. So if you're in either of those district councils, you'd like to participate, again, please let us know and we'll do what we can to help get you connected and registered for those events. And with that, I thank you again for your time and attention, and I will open it back up with Steve and Jeff for any further questions or comments.
Thanks, Wayne. Today's webinar, you can see, was a very thick subject, but it's something that we had to address. Wayne is in the safety department is here to answer any follow-up questions that you have. If you need assistance on pre-qualification or incidents, we're here to help you. Also, to reiterate what Wayne said about our outreach to you folks around the country is the 1 hour lunch and learn. It's just our way to keep in contact with you. So for 1 hour, you have the floor. It's for you to tell us what's on your mind and how can we help. And what we've been finding out is there's different issues in different areas. So for 1 hour during these calls, bring your lunch, put your feet on your desk, and tell us what's on your mind. And if we don't have time to address it then, Wayne, Jeff, and I will get back to you to help hopefully prevent some costly delay, misunderstanding on a regulatory issue, things like this. So it's just our way to dealing with these tough times to keep the communication open using today's technology. So thanks everyone for joining us today. And Wayne, thank you for your subject matter expertise on this subject, which is well represented. So thank you all.
Thanks, everyone.
Jeff, did you have any comments?
My only closing comment is there was a number of questions that we didn't get to, but we will circle back as the team and we'll make sure that we get that out to all the folks that were registered through your email. Along with, important that we mention that we've recorded this session, maybe for a review or to share with other folks in the industry. Thank you.
Great, thank you, Jeff. Steve,
Lastly,
thanks everyone.
Lastly, I think we need to thank Christy Rose on here. I think she's somewhere. And Christy's been a big help in using this technology, getting all of us to use this to get panelists on there to share with our people around the United States as well as Canada. So, hey, Christy, wherever you are, we just want to say much thanks for all your help with the safety department. That's all I have.
Thank you.
Thanks, everybody.
Everyone.